try and give you a little guidance of where we're going this afternoon with the 4 matters we have before the committee today. This is the House Judiciary Committee for our Tuesday meeting. I've got House Resolution 1655 by Representative Kirby, which we're going to take up first. Then we have Senator Miller's bill. Is Senator Miller present yet? Apparently not. And then we're going to do Senate Bill 386, and last we'll do Senate Bill 350, since we already have the most discussion on that particular matter. So to begin, we have Resolution 1655 by Representative Kirby. So please proceed.
Thank you, Mr. Chairman, and it is a pleasure to bring you House Resolution 1655 today. This is a simple urging resolution to send to our congressional delegation in Washington. It just is a reminder that we in Georgia believe in the Constitution and upholding the Second Amendment, and want them to do the same. Also reminding them that nobody has the authority, short of following what the Constitution says, to make changes to it. And we believe in it very firmly and strongly, and also the fact that the rights of the people in the state in the 10th Amendment are fully in effect as well. And since there isn't anything limiting the rights of the people that in the Constitution, that it should be followed and abided by. And
all right.
With that, I'll entertain any questions if there are any.
Somewhat of an urging resolution that we're
Yes, sir.
doing. Okay. Any questions from members on the committee of Representative Kirby? I don't see any. So we think everybody apparently understands fully what your intent is. Does anyone else wish to speak to the committee on House Resolution 1655? If not, we'll close off further public input, and the resolution is now in the breast of the committee. Do we have a motion?
Do pass, Mr. Chairman.
There's been a motion and second do pass. Do we have discussion on the motion? If there's no discussion, do we have any proposed amendments? There being none, the chair will call the main question, which is do pass House Resolution 1655. All in favor signify by saying aye.
Aye.
Opposed, like sign. No. Chair rules the ayes have it. The motion passes with resolution to be set on the rules.
Thank you, sir.
Thank you. Is Senator Miller here yet? If not, I know, but no one's doing anything for Miller. We'll do 386, call for 386, which is Senator Albert's bill, and I had a report earlier that Mr. Jacobs, you'll be handling that, so that'll be the next item. Oh, excuse me.
Thank you, Mr. Chairman. This is the redaction bill that adds the new code sections that model Federal Rule of Civil Procedure 5.2 in the Civil Practice Act and in the Magistrate Code. As members of the committee will recall, this bill was recommitted back to subcommittee for a couple of edits. We have made those edits and sent it back forward. The changes are really just twofold. One, there were places in the bill where the inclusion of the Social Security number, bank account number, etc., in a garnishment proceeding was required if known to the plaintiff, and then other places where it was required if reasonably available. We have revised all of that to make the standard if reasonably available. That's the first change. And then the second change is just that, and this was to address a concern raised both in full committee and in subcommittee by Representative Evans, who wanted to ensure that we included the full Social Security number and or financial account number on the copy of the summons of garnishment that is provided to the defendant, in addition to the one that is provided to the garnishee. So that is the choice we have made on that issue in a couple of places in the bill. You'll see that on line 28, for example, and you'll see it again on line 101. So those are the changes, Mr. Chairman. I would ask for the committee's favorable consideration of this substitute, which is LC 390755S.
Very well, thank you. Any questions by members of the committee of the presenter? There are none. Anyone else wish to address the committee on Senate Bill 386? I see none, so we'll close off further public input. Chair will entertain motions.
Do pass, Mr. Chairman.
Have a motion do pass.
Second.
And a second. Any further discussion on the motion? Any proposed amendments? There being none, we'll call the main question, which is a do pass for Senate Bill 386 as a substitute bill. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Judge Lane, I'm sorry, I forgot to recognize Judge Roger Lane, who served for 8 years with us on this committee and is now the judge in the Brunswick-Glenn County, what do you call that circuit? Brunswick Circuit, okay. If you'd like to come over and have a seat, do we have any other members of the judiciary here? He has kindly come to visit with us. We'll give you one of the seats over here. You've been on the committee. We'll just put you in here to start voting with us.
Yea or nay?
That's right. And we don't have Senator Miller yet. I've called for Ms. Utterman to come in, and she has Senate Bill 350. What bill do we have on that? Did you get her? We'll take a moment's recess till we get Senator here for Senate Bill 350. Where do we have? That's her original bill. Well, we had that in here.
Here's the one. There's the one that they were messing with this morning.
Yeah,
Did you get it broken?
I think they've been separated now. The two issues have been separated.
Oh, they have?
Yeah, that's what I'm being told.
You know, they're not trash can room right behind you.
Yeah, I took that language and talked to Andy about it some, and Andy was afraid that that would open the door that they could come back in and redo everything, I mean, sort of like overload you with information. And he wanted to do it just narrowly to rebut information presented. In other words, I don't want to change my comparables, I don't want to change any measure. Yeah. Well, anyway.
I'd rather keep it more, but I want to be very specific in that.
Okay.
Because they need to provide all the documents up front.
Well, except for the
Okay.
thing, what I was thinking about.
So I just realized we don't have in our folder the as passed bill from the Senate, so I'm having to hold up for a minute to do that. If you want to talk about the bill, we can do that, but I want to have the members of the committee with your bill that came over.
Okay. I have a substitute, Mr. Chairman. Can I start?
Which number is it?
Okay, I
Senate Bill
am,
350 CSFA2?
no. I'm working off of LC 371780 ERS.
And that's the one I don't have.
That's a substitute to 350. And then I have,
What I got to get to the committee members
okay.
is the specific bill that was passed by the Senate.
Oh, you want the bill that was passed by the Senate?
That's where we work from.
Okay. I thought you had been given another substitute.
It may be, but the one I'm showing in my folder is not the one that you talked about, is it? I guess SP 350 CSFA /2. I don't know who that is.
That's the version that passed the Senate.
What, pardon me?
This is the version that passed the Senate.
This is the version that passed the Senate. Ah,
Mr. Chairman, I don't have
Okay.
that copy. If I could have a copy.
we'll get it for you. Get her a copy out of the folder,
Thank you.
please. All right, so what we have is your bill has passed the Senate,
Okay.
and we'll start from that.
Okay. Mr. Chairman and members of the committee, I appreciate you looking at this, and I guess I will go over what passed the Senate and then the substitute, maybe. Is that okay?
Yes, ma'am.
So, Senate Bill 350 is bidding out of child welfare services to community-based providers. And the bill passed. I'm sorry, I did not know that I was supposed to bring that one. I'm not sure what the vote count was in the Senate, but it did pass the Senate, obviously. And what it basically does is divides the state up into 15 different regions and has lead agencies that can be nonprofit or for-profit agencies that are accountable for community-based services of foster care children. As most of you know, there are approximately 20,000 children in the state of Georgia in foster care, and it's my understanding about 10,000 of those are actually kids that go from house to house and in different locations. And 50% of Georgia's foster care children are already privatized, and what this bill does is further privatize that 50%. If you go through the bill, it defines what constitutes child welfare services, and that's very important. The main thing that we're trying to do is move towards more family preservation and teaching families reunification. One thing that I feel like is lacking that could be better done. It also includes emergency shelter, residential group home foster care, therapeutic foster care, intensive residential treatment, foster care supervision, case management, and post-placement supervision, along with family reunification. On line 22, it describes what a lead agency is and what constitutes one. The main thing that the bill does is it has a plan of action, and I had a lot of people say, you know, we're moving too fast. This is being implemented too fast. But when you look at the plan and how long the plan takes, you know, it's a 2-year plan. It's not like overnight you blink your eyes and all of a sudden we're going into further privatization of that 50%. And the deadlines, and as you know, the state has filed for a waiver, and they filed for the last implementation of that waiver on February 28th. This plan calls for the plan being submitted by January 1st, 2015. So that's a year away. It gives us time. And then it's phased in over the 2-year period beginning July 1st, 2015. So I think that that's an invalid argument of, you know, we're doing this too suddenly, that we're doing it too quickly, that it is a plan. The next section, 49 to 31, goes into talking about how you develop the plan and what you do the plan. One of the things we heard when I also had a stakeholders meeting like you did, Mr. Chairman, I appreciate you having that, was having people who are vested in the community on a board overseeing the implementation and the plan and making sure, like in the 15 region area. one of the things that was a big concern was when you divide the state up into these 15 regions, that our state is very diverse and it's very different. When you consider the 18-county core metropolitan area and you compare it to the North Georgia Mountain region, or you compare it to South Georgia, and the ability to like in South Georgia, where we don't have providers, we don't have professionals like professional counselors or psychiatrists or psychologists that take care of children, to be able to go within that region and to be flexible. And that's all of what the waiver application is about, is flexibility and being able to adapt to your state. The agency, that was another concern about whether the agency would still be in control, and it's not unlike how DCH implements contracts through their services for health care, that the agency, DHS, would still be in control and controlling contracts, and if they're not adhering to contracts, to be able to change the contracts or withdraw contracts. On page 5, it gets into assurances. That's one of the things that we wanted to make sure of on the competitively bid price services, that we make sure we have quality control and making sure that these children are overseen, and make sure they have outcomes and achievable outcomes and outcomes that are better than existing outcomes. And that's on page 5. On page 6, it talks about financial audits and making sure that these lead agencies are viable and stay competitive, and they're again adhering to their outcomes. And let's see, I think the main thing about this is on lines 184 and 188, where it talks about if you do not receive this federal 4E waiver demonstration project, that we basically go back to square one, that this would not be implemented. And if you want to switch to the substitute that I presented to Senate Bill 350, and I'm working off of LC 371780.
I don't think we've got that one.
I think
Was that
we
brought to
it.
us?
Yes, sir. I believe it was.
Okay. Tell us what's in that bill.
This changes it a little bit. It is also the same principles of bidding out in the privatization of child welfare services. The difference that I heard from stakeholders, and I think that you heard from stakeholders, this on page 2 sets up a child welfare service planning commission, and that planning commission is kind of like an oversight with the department and working with the department to make sure that it's implemented correctly. And the members of that commission are 5 members shall be appointed and served by the governor, 3 members by the lieutenant governor, and 3 members by the Speaker of the House. It also, we heard from the community, vest some stakeholders into developing the plan and overseeing of the plan. It still keeps the first 15 service regions. It still keeps the 35% rule of lead agencies controlling 35% within the region. And I think that is basically the main thing. It kind of slims down the bill and is not as definitive as the original bill.
Okay. I think you're going to have some questions from members of the committee.
Mm-hmm.
And Ms. Oliver?
Thank you, Mr. Chairman. I am trying quickly here to compare the as-passed version with the 1780 version.
Yes.
And it looks like the substitute you brought is still on lines 86 to 89 contingent on the waiver granting, but it does not seem to have the language about seeking, I have the substitute. Doesn't seem to have the language about asking for federal Children and Family Division permission. I'm really confused about the logistics of this because the waiver letter went in about a month ago, and it was
February 28th. Oh, you mean the original one?
the original
yeah,
waiver.
January.
And the logistics, the draft of it was very
Door shut.
vague.
Right.
It was wide open.
Right.
And based on your contingency language here, 86, 89 of your substitute, I can't tell whether or not your plan is going forward is contingent on the exact,
Yes.
on what exact decisions the waivers made. What is the
was-
timetable on the federal government responding to the waiver, if we know?
I'm not sure. I don't
So
know.
if we don't know when the waiver is going to come back
Mhm.
with a possible yes, I don't see how we implement any other provision
September?
of the bill.
They're telling me September is when we're supposed to hear.
What's that?
September.
So if the federal waiver doesn't come back till September,
Mm-hmm.
and it's an unknown
Mm-hmm.
as to a yes or no, and if it says yes, it's unknown as to what it allowances specifically will be, I don't see how we implement anything or we understand anything about where this is going until we have that definition of
I
what
think-
waiver they will allow.
I think this sets in place so that you know in September if it is approved, you have a plan of action. If you sit back and do nothing, you would have to come back in January.
But you
and
can't
have
make
it.
a plan of action if you don't know what they're allowing.
Well,
That's
I think,
my problem.
well, if I could add, I think it's the flexibility of the waiver that you want. You want it to be wide open so you could decide. I mean, we do have a very definitive plan with regions and lead agencies in how we would implement it. Is getting the community together and discovering those and being ready. To me, it's better to be ready for it than to sit back and you've applied for it and you're waiting to hear from them and then you kind of have to jump into action. At least with this, with the substitute, you would have a plan and it would be more methodical.
But you understand the bill is contingent on the waiver, but
Right.
the waiver's not contingent on the bill. And so your planning process doesn't have any definition. That's my problem. But
Well,
let me move to something
Can I
else.
just answer that?
Yeah.
I think originally when we submitted a bill and the waiver, that we were trying to send a signal to Washington that we meant what we were doing when we put the waiver in, and I think that's what other states have done, is what I've been told. That if you put the waiver in and you have a bill and you have legislative action showing that yes, we're willing, ready, able to go to work and we have a definitive plan of what we want to do, contingent upon that flexibility, that it sends a better message to Washington and your success of being granted the waiver should be improved.
In relation to the numbers you said there were 20,000 children. I think the children in care today are really just about under 8,000. Am I correct about that?
Yes, that's what I said. I said there's about 20,000 that are in different forms of foster care and child protection. That's what was testified. We had 3 hearings
Okay.
in the Senate, and I wrote those notes down. I have them in my office, but it was my understanding about 20,000, and of those, about 10,000 are in some form of foster care. I have the definitive numbers
Okay.
in my office, so
Let's
based upon, I think it was February's numbers.
Let's assume that the number is 10,000 then. You
Right.
said that only 50% of those were privatized.
Right.
I'm going to dispute that a little bit because I'm not sure how you're defining that, because every child in the state's custody is in a private placement. So placement services are 100% privatized. Am I correct about that?
I'm not sure.
Okay, I think I'm correct about that because we don't have a state orphanage and we don't have a state employed foster care They're all privatized services or family privatized contract services. So the actual placements are all privatized.
If that's what you said.
I think so. Okay, thank you.
Further questions of the presenter? Let me ask, Senator, the 15 areas we talked about, that's already established, is it not, as far as
Yes.
there being districts
Mhm.
within the operation by defects of Children's
Yes,
Family
sir.
Services of 15 districts, is that
Mhm.
right?
Yes, sir. I've been to a lot of those, since I've served in the General Assembly, and Savannah's one of the best ones.
And you and I both did hold hearings where we allow stakeholders, people of interest, to come talk to
Right.
us. And the thing that kept coming through from the comments, testimony that I heard was people are in favor of having DFACs looking at alternative ways of delivering services. The question was timing of how we build on that, as opposed to saying, flip the whole thing over and do everything with the private providers. I suggest that. Does your second proposal address how that would be done?
Oh, yes, sir. It changes it because one of the things, like you said, was to planning. The first bill that passed the Senate was for 2 years, and the second substitute bill, the 350 that I'm presenting to you, is 3 years.
Okay.
So it's a slower process. It's still a statewide rollout. It's not a pilot program. It's a statewide rollout in the 15 regions.
Could you direct me to that?
Well, I think you have to look at, let's see.
And by rollout, you mean to have the entire state covered with all
Yes, sir.
15 districts having
I think
services?
it would be line 39 and line 40. The plan shall be submitted by January 1st, 2015, and shall be phased in over a 2-year period.
2 years.
Mm-hmm.
And that would be to have all 15 areas.
Yes, sir.
If they find it to be not beneficial in some places
Mm-hmm.
as opposed to beneficial in others,
Mm-hmm.
is there anything set up to allow options by the department in how those services be divided up?
Well, I think the main thing that the substitute bill, it gives planning to the commission, and it gives that commission the flexibility to be able to decide that. And I think if the commission found that a certain segment of those regions was not capable or they needed more help, they could focus more on them. But that was what I heard from the stakeholders, is they wanted more opportunity to have more input. And the commission shall be composed of 11 members who shall represent local community participation and input through community-based providers, foster parents, members of the faith community, adults who were provided care in Georgia's foster care, and child advocacy organizations that are currently under contract within the division. And that's on lines 26 down. So what the stakeholders are asking for, I think that we're fulfilling by giving them input into the system, and they should know better than anyone if the system is ready to roll out or not. And if it's not, they could revamp it and make changes in that flexibility.
Does the commission serve in an advisory role only, though? Because they're not going to have the ability to actually give direction.
Well, I think they
to the
would be
department.
working with the DHS. It says on line 35, the commission, with advice from the division, shall submit a plan to the governor and the General Assembly to competitively bid the provision. So I think it's trying to get cooperation from the 3 different groups, which would be the provider community, the commission, and then the General Assembly.
I have prepared and also have in the folder a substitute, which is LC 335632S, which takes a little different approach to it, and that is to have really the department, DFACs, go forward with the implementing of a trial program using up to 3 of the districts as areas in which to begin a change of services up to a certain amount over a period of the next 2 years, and report back to the governor, the legislature, of the ability and success of those programs. Have you had a chance to look at that bill?
Yes, sir, I have. I've read it, and I've marked it up.
Okay. And your thoughts on the manner in which we have it done as trial work with 3 areas to begin with, and let the state look at those and have us as a legislative body make the final determination how to then implement the program after that trial time. What are your thoughts on that?
Well, I looked at the bill, and the one thing I did notice from my substitute, you eliminate the commission and you have no provider input. And also it keeps complete control within DHS. And it takes out the purview of the General Assembly having any input into the planning. And you know, it's not unlike a pilot program that we have with the SOURCE program. I remember when we rolled out the SOURCE program in Georgia, that we did it with a pilot program, and that's what this reminds me of, the 3 different regions versus mine, which is 15 different regions. And I did notice on line 40 and 41 the definition of the 35% rule.
Yeah.
Mine was that a lead agency could have no more than 35%, and I think the wording on yours is just a little bit different.
Yeah.
I didn't get that same interpretation, and I would like to keep it at 35% so that you don't have one agency being a single source provider, especially because a lot of agencies concentrate on different things, you know, intensive therapeutic services versus reunification or family planning. You know, all of them kind of concentrate and are better at some things than other things. But other than that, you know, I think your version is just a pared down version.
Anyone else have questions of the presenter? Yes, ma'am. Ms. Oliver?
Forgive me for being hung up on this waiver, because it's the logistics of it. You have waiver language, and I'm looking at your substitute 1780. You have waiver or permission language on lines 41 to 44.
Yes, ma'am.
Paragraph C. And then you've got different waiver language in paragraph E, 86 to 89.
Wait just a minute. Let me get there. 86 to 89.
The difference between lines 41
Yeah,
to
I see.
44 and then 86 to 89, it looks like maybe that's intended that if the waiver's withdrawn or revised, but I can't really. What is your intent with those 2 different waiver languages?
Well, I think we've applied for the waiver, and I think that if we are not granted the waiver, like I said, we go back to square one, that we start over. The line 41 is specifically talking about the commission, and the chairman's substitute does not have that commission, but this is talking about the commission and referring to the waiver.
All right.
And then the lines 86 through 89 are not referring to the commission; they're different. That's the original language from the original bill.
Thank you.
It
We
may
don't
be
have
confusing
several
because
people.
we've had so many
We have
substitutes.
several people who signed up. Want to get everybody an opportunity to address the committee. Mr. Joe with, is it Care Enough Consulting? Come forward if you would. I'll let you slide if you would. Thank you, Mr. Joe, if you all would, because we have several people who are wanting to speak to the committee on Senate Bill 350. Try and keep your comments on direct points. Maybe we don't have repetition too much.
Good afternoon, Chairman and committee members. My name is Kenneth Joe. I'm a registered lobbyist. I was the Chief Administrator for DFACS, the Richmond County DFACS Director, and the Fulton County DFACS Director. I just want to go over a couple of items that Senator Utterman talked about. First of all, concerning the FOIA waiver, again, I just want to clarify that the FOIA waiver is not some type of bonus that you get from the state. It is a cost-neutral plan that you submit to the state that only gives you flexibility on how you use foster care dollars. The federal government could care less whether or not you have a bill up for consideration. They don't take anything like that into consideration. So, all due respect to the senator, that just is not factual. Secondly, on the providers that are behind me have copies of the substitute that you mentioned, Chairman, not copies of the substitute that the senator mentioned. The substitute that has been submitted by the House is not exactly what we want, but I think that it definitely shows that you listened to us when we sat before you last week. As far as the commission that is the Planning Commission that Senator Utterman speaks about, with all due respect, with the idea that it allows community input and provider input, well, in the substitute that the senator just presented, it still is mandating that we follow the Florida model, that we have lead agencies. There hasn't been one provider, matter of fact, there has only been one provider that at your stakeholder meeting, Chairman, that spoke in favor of that. And with all due respect, that provider is funded by Rick Jackson, which is a conflict of interest and does not provide child welfare services. I honestly think that in order for us to ensure that we are taking care of the children and families the way that we are mandated to, not only by the work that we do, but as human beings, that we should slow this down. We should slow this down. We should go about this in the thoughtful, methodical way in which we did the juvenile justice rewrite. We just seem to think, at least in my opinion, that somehow that this is much easier work. This is more complicated work. And so with all due respect, I don't believe that the bill that Senator Utterman, the substitute that she just went over, allows for community input when she is still dictating to the provider community and saying that we want it, that providers want it. Providers are not saying they want it, but she's saying that providers want it, that we want lead agencies, that that's the model that we want. It doesn't work in Florida and it doesn't fit in Georgia. Thank you.
Thank you. Next we have Kathy Culberson. Ms. Culberson.
Hi.
Please introduce yourself and who you represent.
Yeah, Kathy Colbinson. I'm a licensed marriage and family therapist. I've got 30 years experience in child welfare and the CEO of Chris Kids. We're a private provider and provide an array of therapeutic and child welfare services. And I want to thank you, Chairman Willard, thank the committee, and Senator Unterman, because I think this discussion is really important, and I appreciate the work that you guys have done. I think, though, that the stakes are just really too high for Georgia's children to pass any legislation without a thoughtful, comprehensive gap analysis. So look at what's working, what's not working, and the critical importance of providing services to these children who've been abused and neglected or alleged abuse and neglect that are trauma informed and understand the traumas they've been through. I think the two substitute bills both take into consideration provider input that was provided both at your hearing and Senator Underman's hearing, and I really appreciate that. I still think, though, that Senate Bill 350, what it could do is it could, another substitute, provide for legislation that asks for a comprehensive gap analysis of what's working, what's not working, and the establishment of a commission or a committee or a planning council to really take this next year and really do a thoughtful analysis of what needs to happen in terms of child welfare reform. And then the next legislative session, we could be debating a very comprehensive, well thought out reform for the child welfare system. So I think that this is an important discussion. I appreciate the opportunity to come and share my thoughts, and I'm not going to take any more time.
Okay, thank you, Ms. Culberson. Appreciate you being with us. Carl Lehman. Mr. Lehman.
Thank you, Mr. Chairman. My wife often tells me to put a sock in my mouth, so today I will be uncharacteristically brief. I thank you for listening to us and for Senator Unterman for holding the stakeholder meetings. I'd like just to make available to you the comments that I had made last week, some extra copies if you need them. But I just want to make two comments in all of this. Is the lead agency model has been tried in 3 states, to the best of my knowledge. There's another state that's looking at a modification of it. In 2 of those states, it has failed to adequately protect children. One state has produced the same safety outcomes that Georgia has. Florida's experiment with the lead agency model vis-a-vis child safety has been a failure. And some of the safety outcomes that you'll see that from 2003 up until this year, the frequency of children re-entering foster care has been increasing, and that the lead agency model has not effectively dealt with those core safety problems. Voices for Georgia's Children held a conference a couple weeks ago, and we had representatives from Florida, a person who used to work in the state government that had worked through the implementation. We had representatives from Texas, Nebraska, Kansas, and Louisiana. And we had people representing the Casey Foundation. All of them said the same thing. The most important first step in reforming child welfare is broad stakeholder participation and buy-in. This has not happened with SB 350. Secondly, they all talked about the importance of careful and methodical planning, and what Together Georgia, I'm the president of Childkind, a nonprofit foster care program and family preservation program, and on the board of Together Georgia. But one thing that we've talked about is the importance of having a study group that would examine other states, how they've managed foster care reform, and look at those states that have produced the best outcomes, whether it be adoption, whether it be child safety, and then look at how we might adopt some of those best practices in Georgia. Such a group could include justices from the court system to CASA people, people working in the state office, whatever. But the importance of having a methodical process and a study group to examine how best to apply reform in Georgia, as opposed to taking a model from another state which clearly isn't working and apply it to Georgia and expect that we'll have better outcomes than we're having now. And I thank you.
Any questions of Mr. Lehman? What state is, you say, is it working? What state are we talking about? Is it Florida model? I've heard that used several times.
Well, what I've heard that there's some outcomes. North Carolina, for example, has very good outcomes vis-a-vis children reentering the foster care system. Michigan, what I've heard is they've developed a very interesting payment model that looks primarily at the diagnosis and the care needs of the child and determining how to budget for the services. Louisiana is not privatized. They've gone a public system route, but they've made a lot of substantive changes and engaged churches and local community organizations to help them recruit foster families. Tennessee has done one of the best jobs at getting kids out of foster care and into adoptive homes in terms of the amount of time it takes. So different states are good at different things, and I think we would be hard-pressed to find one state that's doing a good job. But Florida, I don't like to beat up on them, but in some of the safety outcomes, their rankings are, for example, for children reentering foster care who'd been in foster care, or children who'd been reunified with their biological families, that within 12 months of exiting foster care, they're back in the system. Depending on the length of time, they rank between 27th and 48th in the country. So I just don't think the lead agency model is one that is really worth examining.
Thank you, Mr. Lehman. Next, we have Wayne Drummond. Mr. Drummond. Yes, sir. Thank you. Late. Thank you. Have a seat.
Thank you, sir.
Give us your name and who you represent.
My name is Wayne Drummond. I'm the Executive Director of the Georgia Professional Human Services Association. We're an association of 1,000 people across the state that work in human services and have a mission of supporting outcomes for families and children and actually doing the work. I want to first acknowledge the great work of the leadership of our state in paying attention to the child welfare system. The addition of staff by the governor is wonderful. Your attention in listening to the provider community is also exceptional. We appreciate Senator Unterman bringing forth the bill that addresses the foster care system. I'd like to know that in looking at any large system, even small changes can make a big difference on the lives of children. We have 7,700 children in care in the state of Georgia. If you transition to a different form of service, a Florida-based model, and assume that that transition takes just 30 days, you start adding up 30 days for 7,700 children, you end up with 80 years of children being in foster care, 80 years of work to transition them to another system of service, when we should be working on better outcomes for them during that period of time. That would suggest that we need to have good reasons for doing this. If you look at the outcomes in Florida, Georgia does a much better job of assuring safety when we reunify children. Florida puts children back in homes more quickly. Those two factors coupled together could be a very good indicator that they're making decisions that could be made better, more rapidly, and we want to be very cautious in approaching this. I'd also like to note that county boards of family and children services across the state advocate with local county commissions to put millions of dollars in our foster care system. Most of those dollars can be matched for additional services for children. If you go to this regional type of model, counties are not going to be willing to put forth money on behalf of their children to serve a regional model. They're more interested in supporting the children in their community, and I think the loss of those funds would have some dramatic impact. We would just encourage your continued caution in looking at this. We don't believe that Senate Bill 350 in its original form from the Senate is the best way to go in improving outcomes. I would also note that the issues we've had in family and children services over the past year are not functions of the foster care system. Our foster care program is working reasonably well, and I think better than Florida's. It's issues of the Child Protective Services system. I've had the privilege of working in this area in our state for 41 years now, and I will tell you that the response of the division in working with other partners and the General Assembly to strengthen outcomes in the Child Protective Services area to ensure external reviews, additional training, a centralized intake is one of the most comprehensive responses I've seen to challenges over time. We're doing some good things. I thank you for your consideration. Certainly the House substitute that you propose certainly shows and reflects some good acknowledgement of the good work that's been done in our state in the foster care area and takes a much more measured look at ways to move forward. Thank you very much.
Right, thank you, Mr. Drummond. Next is Rachel Ewald, I believe. Ms. Ewald. She is.
Thank you. I'm Rachel Ewald. I'm the executive director and the founder of the Foster Care Support Foundation. I'm probably the only one in this room that's not either a government employee or a provider, but we serve all the children from the government agencies and the provider agencies that are on basic care per diems in foster homes. So we have a unique perspective of how the foster care system works from within and looking at from a position that we serve both types of homes. And I can tell you right now that in the past, county homes were lacking in the quality, but that is not the case anymore. Georgia has done a fabulous job of recruiting better homes, better quality homes. And one of the reasons for that is that we've been in operation for 13 years, and we've tried to bring out a lot of awareness of the need to help the foster care system. And we have seen, we've already been working in what this bill is supposed to be doing. It's already doing this. We are already doing this within our counties, our neighborhoods, our communities. I'm going to give you an example. Forsyth County went ahead. I met with them last year, and they decided to take the bull by the horns, and this is a DFACS worker who is a recruitment, and she went through her community faith-based organizations and businesses and different private areas, YMCA, and she started talking to the community about the need to support the DFACS system as it stands to strengthen DFACS from within, not to create another whole entity that's just going to throw money at someone who's going to tell someone what to do, but to do it. They went from having 4 working homes, 7 in all, but 3 were actually taking a break. Either they just adopted or they were taking a break from fostering, and they needed more homes. So they were spending all of their money on privatizing, meaning putting all their children into private placement. It costs 3 times more per day per child to put that child in a private agency, even for a regular foster home, because the foster parent, although they will get the same amount per day as the foster parent for the county will get, you have to pay almost twice that much to the agency for housing a home. That does nothing to make a better care for that child. It's just paying them to house a home. Well, they went in less than a year. They will have, at the end of this month, 30 great new homes, and they are no longer having to place all their children outside the county. Now, that has allowed them to free up money, which would be going to a private agency to really not do better the care for the child, but that money has now allowed them to hire more caseworkers and recruit and care for their foster parents and their children in the way that they need to do. I would think that it would be better spent to, rather than a bill that is going to completely privatize a system that really is going to cost us millions, and I would say over $100 million at least, minimum, to concentrate on what isn't working right now in DFACS, meaning we need to pay more money to our caseworkers. How many of you have a $30,000 a year job, but yet you have the life and death situation put in your hands, and every day 15 to 45 cases, and yet you wonder why the retention is low? At your stakeholders meeting, you asked this question on why can't they retain, why is the turnover so large? Well, they didn't answer it, because at the time you were asking it for the agency that, in all due respect, they want to be the lead agency, and they didn't give you an answer. That is one of the reasons. It's a highly stressful job. It is probably one of the most stressful jobs you can have, because you are in charge of making sure that your decision on this child is going to be the right one. Is it going to be dead tomorrow if I return this child home? But yet they're getting paid $30,000 a year. If you give these people some support that they can actually take care of their families on the pay, they won't be leaving as fast. If you put that money into the amount of workers that you have in DFACS, into recruitment, that will definitely be better spent than privatizing a bill, passing a privatized bill. If you think of how we work at Foster Care Support Foundation, we knew that we needed more homes for children. So what we did is we reached out to our communities. We created an organization that is not government funded, not a penny, but is funded by our communities, the people who have vested interest in helping these children have improved lives. We serve 3,000 children a year. We've served 36,000 children since we incorporated in 2000, and this is with no government money, by sponsors, by community input, and 5,000 volunteers a year come in and serve and do the work that we need to help these children. Now, churches already help with healing families that are hurting. They've been doing this for centuries. They already know the plan on how to do this. They don't need a lead agency to tell them how to do this and to tell them they have to spend money to take care of this. What I see in this bill is I see a lot of money going to agencies that will then tell the communities what to do, and the communities will pay for it. And that's just not going to happen, because if they see all this money of their tax dollars going into an agency, they're going to say, well, I guess we step back, let's let them do the work. And so all this good work that's being done by our communities now will probably take a halt. And that's what I hate to see. If we can look at the program that we have right now, which is encouraging the neighborhoods, the community partners to help strengthen DFACS itself, I think we'd be much better off to look at that plan, and down the road, that Title E money or whatever the waiver can be used to strengthen that program without creating a Pandora's box that we can't get out of once we pass. And thank you.
Thank you, Ms. Ewald. Next, we have Ron Scruggs, I believe it is. Thanks, sir. Identify yourself and who you represent, please.
My name is Ron Scroggy, and I'm currently the Executive Director of Together Georgia, representing about 70 service providers in Georgia. Also, just prior to taking this position, I was State Director of DFACS for 2 years. And prior to that, I've worked about 30 years in the private sector, running a program called Inner Harbor Hospital. First of all, I just want to take a moment and thank Senator Unterman and yourself and all the folks on bringing this conversation to a head. For those of us in the room who have worked with child welfare for a lifetime, it's a long overdue conversation. So I want to thank you all for that. I have had a chance to look over your substitute bill, Chairman Willard, and I would like to say that, again, thank you for listening to us last week in the stakeholders meeting. I think the substitute does a great job of taking information that's been given and incorporating it. Particularly want to thank you for a couple areas in it. The first section where you basically are acknowledging the work of DFACS and the current work that DFACS has done in working with private agencies is much appreciated. On the second page where you talk about the 2-year pilot program, I think from my way of thinking, in such a major reform, that is exactly the right way to go. Having overseen a couple statewide rollouts of major initiatives as State Director of DFACS, you're dealing with a very complex 159 counties that not too long ago were actually running county systems. So you still got a lot of cultural issues. Senator Unterman is absolutely correct. Different parts of the state operate differently. I visited 77 offices while I was State Director of DFACS, and they all run differently. So the idea of running pilots in which you can step back afterwards and kind of evaluate and determine which ones work, what might be work better, I think is a welcomed addition to the bill. And then lastly, as far as the substitute, on your final page, you've got some very general, but you've got some outcome measurements that you think should be included. I think the notion of setting some vision and setting some expectations for this work we're doing in this bill and doing in reforming child welfare sets a course and sets some purpose in the work. So very much would like to thank you for that. I also would just like to close by saying whatever happens with Senate Bill 350, whether it's this substitute or any other in its current format, the issue that came to all of our attention in the fall and the issue that continues to dog us is child safety and child fatality issues in Georgia. Having been State Director of DFACS, we worked really hard to try to bring that to the light of day for the reasons for a lot of those situations. And the legislature needs to consider appropriations in which CPS and investigations can be bolstered, because DFACS cannot do this without some attention with regards to enhancements. So I thank you.
Good point, Ms. Scroggy. Sorry I mispronounced your name.
That's all right.
Glad to have you today. We did not have anyone else signed up, but if there are others who would like to address the committee briefly, we will happily try and accept your opportunity. Do you have I'm a parent. A parent? Yeah, all right. Come on, please come forward and let us have your name and if you're representing any organization or just yourself.
My name is Annunciata Hippolyte, and thank you for hearing me. I'm a parent advocate, and everybody is here representing the child welfare. I'm representing my 17-year-old who has been taken from DFACS the wrong way. DFACS said their job is in the best interest of the child. It's not. We sit here, nobody hears about what the parent has to say. Just because I lost my house does not make me unfit mother. Just because I'm sleeping in a car with my daughter does not make me unfit mother. I only have one child. I was approached by DFACS. In 3 days, they built a bunch of paper lies that I suffer from mental illness. God has given me a sound mind. The third day I went to court, especially they don't even come and take the child from me. They took her from school. Then the next day I went to court. When I went to court, I was charged with deprivation. When you come and take a child from a family, you look at the needs of the family, not what the policy said.
Well, actually, we're not here about a specific instance. I understand you're concerned about what happened to you. We're talking about the programs of DFACS and the approach that's being taken by this legislation as to further privatization of programs as a model or way of trying to deliver services.
Okay, I believe in the privatization, Your Honor.
You do believe in it?
I do believe it. Anything that take away power from DFACS as far as family is concerned, there would be more people involved.
Good.
Because when the children is in the privacy of a home, the things that they went through, the things that my daughter went through shall not be. When the door is closed, you don't know what is happening, Your Honor. You don't know what is happening. I support the privatization.
Thank you, ma'am.
All right.
Appreciate it. Anyone else wish to address the committee? And if not, we will close all further public comment. And the bill is now in the breast of the committee. We're open for discussions. Ms. Oliver?
Mr. Chairman, it may be
pull your mic around for me.
It may be appropriate for me to go ahead and make a motion at this time to bring a specific.
I'm waiting for a motion. I'll call for motions in just a minute. May I?
Yes, sir.
I'll call for you the first one.
All right.
I'll call you the first one. You've asked for that. Any other comments? I wanted to comment because I am the supporter of a proposed substitute, and the thing that's really interesting is that we're all here with the good heart intentions of trying to find the best way to improve what are the services the state provides through DFACS for those in greatest need in our state, which are the children that the state has an interest in, has taken into custody as a part of the laws we have with the state. And what we're trying to do is find a better approach, be that with using private sources as a way of providing the service, mostly looking at the interest of how these investigations are handled and the quality of the outcome for the children themselves. What we have here is, as you heard, is a program that I wanted to see implemented, which is a pilot program to start for a period of 2 years, have DFACS recognize 3 areas, up to 3 areas in the state that may be appropriate districts, we call them, to begin with the changeover of services and determine if, looking at it, what's worked well, what hasn't worked well, whether we can make further changes. I'm concerned if we make a complete change without having an opportunity to really do a full evaluation of it, we may be, as I've heard from Florida, who went through this, creating the same potential problems in our own state. I think we can avoid that by letting first there be 3 regional areas for the delivery of a certain amount of the services through private agencies that we're not utilizing now, and from that have these reports come back to the General Assembly and to the governor. I am not concerned so much with DFACS being the one providing it. I think it's the appropriate thing. Let's realize also DFACS works under our governor as part of the executive branch, and it's the executive branch that we look to come back to us as the legislators with proposals and recommendations which may be improvements of services or additions or deletions of services. So I've tried to take that approach with Senate Bill 350's substitute, which is LC 335632S, and that's the basic premise for it. That's the chair's comments. Does anyone else wish to speak or address the committee on this matter? Ms. Oliver, I'll entertain motions.
I move for committee do pass on LC 335632S, and I want to say something about privatization too. Since none of the substitutes that we are considering seek privatization of the investigation portion, the protection portion, prevention of child abuse portion, all my comments directed really to service delivery. Since I believe all children right now are being served in a private placement, what is left to privatize is some management services and oversight services of those providers, some recruitment and some training, and I have a particular interest in adoptions. We have done a number of different things historically on privatization of adoption services, and we have had one very long, specific 10-year Woodruff financed privatization approach to training, which was successful and non-successful. And I think it's really a good time to look at those individual specific delivery arenas. I don't think we can achieve what we want to in a very focused way by an overall creation of a new bureaucracy similar to what I consider the CSBs in the regional areas. So the pilot projects give me a lot of hope that we can be very directive in that way.
All right. You've made a motion to
do pass
33 substitute
5632S.
Is there a second to the motion? Second. It's been moved and seconded. Any further discussions? If not, the chair will call for a vote on the substitute of LC 335632 as a do pass. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. All right, we'll go forward with that, Ms. Onderman, and keep you abreast of what happens. Thank you. Thank you, ma'am. Let's take a moment. Let the persons who like to leave the committee room do so. Please do as quietly as you can. If y'all would move away from the door outside also, that would be a help.
Yeah.
Mr. I saw it. I got it. He's
a good hiding spot if you can't find me, I'm getting behind the door.
That's it. I can see a little side of him right there. A little side of him.
You tell Fran you can feel his aura.
Yeah. Nope. Supposed to be carried by Mr. Rogers, unless they change that for any reason. Mr. Miller, we're happy to have you. We're about to close up the door. I think we'll let you sit down. And
took me 16 years to get in front of you, Mr. Chairman.
I've waited a long time too. I've waited a long time for this. Let's bring the door to, please. Shut the door for me, please. Shut the door. All right. Thank you. Thank you, Mr. Hollidan. We have now the pleasure of considering, is it an education bill? Retirement bill. His retirement?
Are you referring to our age of myself and the chairman?
Senate Bill 293. Is that the one we're on?
Yes, sir.
All right. Tax assessors.
LC 296035 ERS.
You're correct. Thank you.
Okay, sir. Would you like me to start?
Please.
A couple of things. I was handed 2 amendments on the way in here that I had not seen before. Little background on this bill. It was brought to me by a constituent. I sat down with a gentleman who's done a lot of appeal work in the Metro County area, and he, as the subcommittee knows, put together a book with a whole bunch of changes to try to level the field for the taxpayer, if you will. And we actually, I think, had some very good dialogue. We had representatives from the Metro County assessors. I've heard from people like Camden County, some other folks as well on the particular bill. As it worked through subcommittee, particularly with, and I really must compliment, much as I hate to do it, Subcommittee Chair Jacobs for the work he did on this bill. What we did was to make sure that people understand that we're not affecting the mass appraisal system at all, which is what a lot of counties used to start with. And so what we've done in Section 1 is once someone decides to appeal and they make a written request for that, they then are entitled to get all, by certified copy, all the documents that have been used in order to come up with the comparables in their appeal process. They've got to pay for it according to whatever we charge for copies by the Superior Court, et cetera, Superior Clerk, excuse me. That's Section 1 of the bill. Section 2 in the bill, what it does basically is when there's not a revaluation, we didn't change the law up to 180 days. If they don't respond back, the Board of Assessors, to the taxpayer within that time frame of 6 months, then whatever value the taxpayer submitted on his appeal, assuming they have put in a value, will be what the value is for the upcoming year. Also, they also are allowed to, they're supposed to be notified about a hearing. We said if they don't hold the hearing within 30 days, then again, and the taxpayer didn't ask for it to be extended, then again, the same thing, the value he submitted be what is used. There was an amendment given to me that changes the 30 to 90 days. I have no problem with that, just so everybody knows. That may be from you, Mr. Chairman, I'm not sure. Okay, so that's not a problem on the 90 days, which is line 46, and there's a separate amendment that you probably have in your folders, which I hadn't seen before. The next thing is, we had some issues that the taxpayer is allowed to request an interview, but evidently in one particular county, the court didn't feel that way, so we're specifically saying, yes, you can have an interview, number one, and number two, you can record it. Because, again, you can go on to, now I'll use my legal knowledge that I've learned after being in the subcommittee, go on to a de novo hearing in Superior Court. So, and again, all evidence is, as I understand, the game starts over at that particular point in time. So you can have documentation of what's actually transpired. And the last thing is when you get to the appeal process and you get the comps provided, right now, the appraiser, they're supposed to take into account distressed properties, or excuse me, distressed sales, bank sales, et cetera. And all we're saying now, you also need to take into account distressed properties. If somebody's at the end of a cul-de-sac and there's 3 houses boarded up on their street, but they haven't been sold, but they are distressed properties, they should be taken into account of the value of a home. And after Chairman Jacobs' perfection of the bill, I think that really does it. And I can't really speak to the AM 340647 amendment. I think I know what they're trying to do there. But is that from you, Mr. Chairman? No. I have no idea where that's from. And when we finished in the subcommittee, we had several of the appraisers here, and everybody said that this seemed all to be a good compromise. So I had not seen the amendments, but I don't have any problem with the 90-day one. But it seems to me that what we're trying to do here is for the taxpayer, if he wants to appeal his tax bill, he needs an area code section that he can understand. And here's the process, and here's what you expect, and here's what you need to do. And I've never been in front of this committee before, but I think a 3-page bill out of judiciary is pretty good. And I'll leave it at that.
All right. Thank you, Senator. Any questions of the presenter by members of the committee? I see none. Get off easy. Wait, somebody did. Ms. Stevenson, excuse me.
I like the fact that lines 14 to 25 seems a little bit like discovery. My question is, when the appraisal goes out, will the taxpayer know that they have a right? Is there going to be a notice in that they'll have a right to request this information within the 30-day period?
That's a very good question. I don't think we've addressed it in this section here. There probably should be something maybe in a tax bill. I'm trying to remember. I'm going from memory that if we have that already in a tax bill, I'm not sure.
Well,
Steve,
it
is there
says
something that says that now?
it says you have a right to appeal, but
No,
this
but I'm
gives
just saying,
you
is there
more.
something that says you have to make right now? Is there anything like that at all?
The annual assessment notice has language in it, but it does not contain anything about an interview. Is that what your question
No,
is?
the written request for an appeal.
Oh, it gives you information on how to file an
yeah,
appeal and all that. That's in the annual assessment notice.
But my question is whether or not they know what they can request and the interview, because these are new provisions.
Right.
So
I don't-
these,
no,
it should be added.
It's not on the annual assessment
Right.
notices.
Right.
And the assessment notice is currently a mandated. The verbiage on the assessment notice is mandated.
We may.
And I can provide you a copy of what's in there now, and I don't recall exactly how that language works.
I guess I know what's in it now, but I'm saying if
No,
we-
it's a very good point that you raised, and if we want to put language in that requires them, like in bold print or something, to let them know, I have no problem with that either.
All right. No further questions of the presenter. Do we have anyone else in the audience who would like to address the committee? Please, sir, come forward, and we'll get Mr.
Steve
Miller's cup out of the way. It's proverbial cup with you always.
You never know when you're caught in a snowstorm, Mr.
That's right.
Good afternoon, Mr. Chairman. Thank you very much, members of the committee. Appreciate the time.
Tell us who you are and who you represent.
Oh, I'm sorry. Yes, I'm Stephen White. I'm the Director Chief Appraiser of Cobb County, and we've worked a lot with Senator Miller on getting to this point, and we appreciate Representative Jacobs working with us as well. Just have one clarification that I can provide, or maybe point that I would make in regards to Section 1 on line, well, really the bottom part, lines 21 through 25. I think that there needs to be some clarification there that if the property that's under appeal is a commercial property or is valued on the income approach, a lot of times at the Board of Equalization or a hearing officer, that's the time that the taxpayer is coming forward with their income information. And so if it's a commercial property or an income producing property, we don't have really any documents to provide them, and I think we wouldn't want to be handcuffed until we got to the hearing. So there might be some, maybe perhaps at the beginning of the sentence there on line 21, when concerning a residential property or something to that effect. Hearing officer does not have very few residential properties because there's a value threshold there and it has to be non-homesteaded. We do have them occasionally where someone has a value of a property over that number, it's residential and it's non-homesteaded, but very rare. Those are generally income-producing properties.
Let me stop you for a moment. If I understand, you're looking at line 21, you're looking at the sentence here that begins after providing the documents.
Yes, sir.
To the taxpayer, the Board of Tax Assessors shall not change, alter, or supplement the documents in making a presentation to the Board of Equalization or hearing officer, etc. Why is that limited?
Because it says after providing the documents to the taxpayer.
So why is it limited?
Well, if the taxpayer walks in, let's say after the notice is granted and it's the summer, let's say it's June, the appeal isn't going to be heard until the end of the summer. That's the time where all the information comes forward, for both the attorney and tax rep in a commercial property. And again, I'm not concerned about the residential properties. And I should say I'm here also representing the Georgia Association of Assessing Officials.
Right.
We understand the Board of Equalization part. Don't have an issue with that. It has to do with commercial properties where we're not getting data.
I'm not being clear on my question.
Okay.
I'm asking why would there be a limitation as to a cutoff date for what may be the sharing of documents which may be used as supporting evidence of the valuation, either by the taxpayer or by the Board of Tax Assessors?
Well, the way I read it, after providing the documents to the taxpayer, the Board of Tax Assessors shall not change.
Or supplement the documents.
So it would be...
I'm saying supplement tells me as a lawyer, you've got further documents you want to provide to be used in evidence.
we would have no issue.
wrong?
We would not be holding any information back.
No, I say you would hold
Yeah.
it back. I'm not asking them.
I see what you're
You
saying.
discover other information that may be supportive of a position either you or the taxpayer has as to what you reached as a conclusion about valuation. Am I reading this wrong as far as how that's applied?
And perhaps I'm reading it wrong.
Okay. We'll get to that in a minute.
Sure.
I think I want to get a report from Mr. Jacobs on that point. You go ahead, if you will, please, and
I
finish
think
your
that
testimony.
the rest is, I think we've come to an agreement on the rest. I can answer in regards to an amendment.
Is this yours?
Yes.
Okay.
Yeah. The amendment AM 340647.
Yes, sir.
Did you want me to comment on that?
You can. Certainly.
That's when we submit a digest, our digest is reviewed by the Department of Audits. This is a clarification to some language that our offices are reviewed upon, and we currently have a situation where the Department of Audits has kind of changed the way that they review digests. They review them in the year after we submit the digest. This just provides some clarification in regards to the numbers that we need, and we have been working with some of the legislature on clearing up this language because the Department of Audits is using a set of guidelines. And
So this doesn't address the material issues we have under SB 293, but something your office, on behalf of the tax assessors, the state, wanted to clear up some existing provisions?
That is absolutely correct.
Okay.
Yes. Mm-hmm.
Very well.
Mr. Chairman?
Yes, sir. Hold a minute. Any questions by members of the committee of the presenter? Now we've got lights going. You want Mr. Jacobs?
Right. Well, and this would, I guess, lead into a question, but it would also respond to the chairman's question, I suppose.
I'm going to give you a chance to just give a report from your subcommittee in a minute.
Why don't I'll wait until
Okay.
then.
How about you, Mr. Fleming?
Mr. Chairman, I was going to go to your question too,
Okay.
and I'll let Mr. Jacobs comment first. That may answer it.
All right. Let's do that. Anything further of either
I have one.
Mr. Miller? Mr. Miller, you want?
I don't think that this particular amendment, the AM 30, I agreed to the other amendment, this AM 340647. I don't think that's relevant to the taxpayer's appeal process. It may be an assessor's issue, but it's got nothing to do with this.
Right.
That's just my opinion.
I think you're probably right. It comes out of the same title, the same chapter. Therefore, it could be a permissive amendment, we'll call it, under the broad rules we have of the House and Senate. Yes, sir.
Yeah, all I'm saying is I think it would
It doesn't
confuse
change
the
the
purpose
bill.
of this. I think it would confuse the purpose of this bill.
Okay.
These 3 pages.
Okay. Mr. Fleming.
Well, I was going to talk to Chairman Miller. I don't want to confuse the purpose of your bill, but I was trying to figure out from your comments if you're opposed to the substance of it, or you were.
No, I'm not opposed to this. I just don't think that this is a bill that's entitled so the taxpayer can know. Here's what you need. Here's the story. Here's what you need
Right.
to do. And I think you put this in the middle of this bill, they're going to go, "What the heck is this?"
Well, it won't be in the middle of the bill. It'll be in the right place in the code if we put it in there. So I don't think what they're reading is going to be messed up.
I will be guided by your knowledge.
Okay, all right.
Okay.
If you was opposed to it,
Was
I
that
was
the
going.
right answer?
If you were opposed to it, I was going to talk to you about it.
No,
But
as
if you're
long-
okay with it, I'm
as
okay
long
with
as
it.
I'm
yeah.
not going to see this part of the bill.
You won't.
It'd be a different part of the code.
We're
I got
good.
you. Okay.
Won't hurt you. Put it that way. Nothing further. All right. Is there anyone else who wishes to address the committee on Senate Bill 293? I see no one else. We'll close off public comment, and the bill is now in the rest of the committee. And as chair, will ask Mr. Jacobs to give us a report of the work done by your subcommittee.
Well, certainly, Mr. Chairman, and the bill we had in front of the subcommittee went a lot further than the bill you have in front of you. We rolled it back pretty significantly, but still have kind of the gist of what Senator Miller was trying to achieve in the bill. To go to your point about the providing the documents ahead of time, the bill as presented to the subcommittee actually went much further than what you have in front of you. It required the documents to remain static after being provided to the taxpayer upon written request, not only in a Board of Equalization hearing or before a hearing officer, but all the way through an appeal to Superior Court after that. Of course, that appeal to Superior Court is a de novo appeal where attorney's fees can be awarded to the taxpayer if the taxpayer prevails above a certain level. And so it didn't make sense at all to tie one. I mean, the whole point of that hearing, de novo in Superior Court, is to get to what the truth is. So we certainly didn't want to tie one side's hands and leave the other free to present whatever evidence they want. So it doesn't extend to the Superior Court hearing. Now, as to your concern about holding the document static, I mean, the point here is to ensure that the documents, if requested by the taxpayer, all of them are presented up front.
Right.
Now, there is an amendment in folders that I frankly, I don't know, given your reference to amendments, Senator Miller, I don't know if you've seen this one or not. It's actually a smaller one that I've typed out. And I would tend to think that if there is, because obviously I think we want the tax assessors to present their case in chief to the Board of Equalization, using the documents they produce to the taxpayer. I mean, I think that that's only fair. But then what happens if the taxpayer comes in and presents some information that the Board of Tax Assessors needs to respond to? And that's what the amendment is aimed at. It would, now, frankly, I'll would certainly defer to the wisdom of the committee on whether we should limit this to an oral response, but it would insert, the amendment at least as written right now, would insert after Board of Tax Assessors on line 24 the language that you see here. So it would read, provided, however, that the Board of Tax Assessors may orally respond to or clarify information or documents provided by the taxpayer during any hearing, and may change, alter, or supplement documents in any subsequent appeal to the Superior Court. We could also kind of change that to make it say, may orally or with documents respond, or we could just strike orally. I think
you also would need to change provided not by the taxpayer but to the taxpayer, isn't it?
No, that actually means provided by the taxpayer at the hearing. So meaning the documents
the taxpayer is presenting to use?
Correct. So the Board of Assessors would produce their documents ahead of time. They're bound to those documents for their case in chief. Then the taxpayer comes in, presents some documents that require a response, and certainly the tax assessor should be able to respond at that point, is the thinking.
I guess we get into the issue of what is due process in this matter. We definitely want to save the benefit of the taxpayer from being surprised. But I think that usually goes both ways. I don't know if the taxpayer is having to produce documents ahead of time at all, is he?
No.
Does not. Okay.
Question, Mr. Chairman? Question?
Yes, sir.
Here's what we're trying to get to here. That I come into that hearing and I've been given these comps. And I walk into that hearing, and all of a sudden I got 3 new comps.
I understand.
That's the problem we're trying to solve.
I understand.
Now, the language you want to use, fine. But that's, at the end of the day, however you best think to solve that problem, that the guy doesn't get surprised, and all of a sudden there are all these different properties. Because we went through that in the subcommittee and other things where that could be a real issue. Not with my friend here on my right, but it has been an issue in other places.
Okay. I understand. I guess when I look at your amendment, Mr. Jacobs, with a small one here, may orally respond to information or clarify. That doesn't really tell them, just say they can respond to that information or documents provided by the taxpayer. Their response may be for purpose of clarification, but it may not be appropriate to use that phrase in there.
Which phrase?
Or clarify.
I thought that was the point of the hearing, but maybe I misunderstood.
No, just
well, I mean, this language by and large.
They orally respond, right? They're orally responding.
Correct.
To the information or documents provided by the taxpayer during the hearing. So the fact they're not able to provide or supplement documents doesn't mean they're limited and cannot respond to that information. But go ahead. I want to hear some more about what happened in your committee on it, your subcommittee.
Well, how so? Oh, about the rest of the bill?
Yeah.
Okay. No.
No.
In fact, I intend to send Senator Miller a bill for my time over the weekend on this one.
And
So.
he did on Sunday, too.
Yes, sir. You have something you want to add to it, Mr. Welch?
Before we leave and talk about the other
Yes, sir.
wonderful discussion that occurred in subcommittee, could you repeat the amendment, Vice Chairman or Chairman Jacobs?
There's a copy of it in your folder.
I have one from Powell.
That's Jacobs Amendment number 2.
Yeah, it's Mark Jacobs Amendment number 2.
Here you go.
I don't have to. All right, never mind. I'm sorry. I didn't have it in front of me.
Okay, okay. I was looking for clarified. I need to just make a response.
Right. Well, and there are two other matters that are dealt with in the, or actually 3 other matters that are dealt with in the bill. One really deals with a failure by the Board of Tax Assessors in the one instance and a failure by the Board of Equalization in another to provide the required response from the Board of Tax Assessors in a timely manner, or the notice of the hearing from the Board of Equalization within a certain period of time. There was no teeth in those requirements, and apparently in many instances, not everywhere, but in a lot of instances, the tendency was just to blow through those deadlines with no consequence. And so the solution to that was proposed in the bill that we refined a bit in subcommittee was to say that beyond a certain point, 180 days for the Board of Tax Assessors to respond, and then 90 days after that response is provided to provide a notice of the first hearing before the Board of Equalization. If those two things are not done in a timely manner, then the taxpayer is entitled to their value that they've put in their appeal if they have requested a value. And of course, the testimony then in the hearing was that in some instances, or many instances, the taxpayer does not provide a value at all, in which case they're not entitled to get a value automatically. We did require the interview with the Board of Tax Assessors if it's requested in writing by the taxpayer, and also give the taxpayer the right to record the Board of Equalization hearing as well. The taxpayer also has the right to record the interview with the Board of Tax Assessors. Also, in addition, if the taxpayer, particularly the taxpayer, does not request the documents ahead of time from the Board of Tax Assessors, any documents that are used by the Board of Tax Assessors in the Board of Equalization hearing, the taxpayer has a right to get those documents, the originals of them, and have the Board of Tax Assessors person sign them right then and there, the representative sign them right then and there so that they can be used in a future appeal. And the final thing there on lines 65 through 76, and we took a different approach than the bill originally took with this particular language. The bill brought language to us. Of course, the Board of Assessors, in assessing a given property, is required to take into account foreclosure sales and distress sales. That's already in the law. Right. The bill, as it was presented to us, also required any distressed property, based on its condition, not whether there's a sale, to be taken into account as well for purposes of setting that value. Obviously, that administratively is a very high burden for the Board of Assessors to know and figure out what is in the vicinity of a particular property. But there is a problem in these hearings where where sometimes the taxpayer will show up and point out distressed sales or point out distressed properties in the vicinity. The Board of Tax Assessors will push back and say, well, we don't take that into account for purposes of our assessing this particular property. And the Board of Equalization will just take that at face value. And so we do think that there ought to be a right for the taxpayer to have that considered. And so we've put in the section that deals with Board of Equalization hearings a right to have any distressed properties or distressed sales considered by the Board of Equalization, so that at least there's something right there in the law that the taxpayer can point to if they get that pushback from the Board of Assessors representative and say, no, no, no. The Board of Equalization is required to consider this evidence.
May I ask a question on that point? If you have a distressed property, it does not, by its term, mean there's been a sale of that property.
Not necessarily. No.
How would you have a way of determining what the current value of that property is because it is distressed? I guess if I'm the taxpayer and I'm saying I've got 2 properties in my immediate block that are distressed properties because they're vacant, the weeds are overgrowing, there's other problems with it. How am I going to relate that as a taxpayer unless I've got a professional appraisal of sales? That's right. Sales is what you said. So I don't have a sale of the property. All I know is I can describe as being a, quote, depressed property. But how can that relate then now to a judgment of value because it is a distressed property?
Well, again, that's a judgment that the Board of Equalization is going to have to make, but I will say this. A taxpayer can, and many taxpayers do, come in with a certified appraisal that is for the that's for the calendar year for this particular property. That appraiser can take into account distressed properties in the vicinity. And obviously that, hopefully, before the Board of Equalization would have greater weight in terms of what the value of this particular property is.
And following up with that, Mr. Assessor, if I have a qualified professional appraiser look at my property and he has considered properties in the immediate vicinity that may be considered distressed, that's his right to do so, correct?
That's correct.
And it can't be denied as far as that. But if someone says, well, I got distressed property, and I think because they're distressed, it's affected my property value by some amount, is there a way to measure that?
It's very difficult to quantify in terms of the effect on the property unless you have sales in the neighborhood that you can show.
You have sales in the neighborhood.
Yeah. Okay. Mr. Fleming, you had a question, I believe.
Mr. Chairman, first of all, I know that Senator Miller has taken an awful lot of time and effort to put into this. Had a guy in subcommittee testified, done a lot of work in DeKalb County, and I understand and hear the distress that some of the property owners have when they go to this. Back to line 21 on the first page, where you brought up the point about when you could have evidence and not have evidence, and when you had to stick with what you had. That what you don't want to happen is the taxpayer to walk in there and be surprised. Yeah, trial by surprise, so to speak, and that's what he's trying to prevent. And I think that's a laudable goal.
Oh, it is.
The balancing act I was trying to figure out was that the way this thing works is that the Board of Assessors hearing and the Board of Equalization hearing are 2 separate hearings. They don't happen at the same time. They're separated by weeks, if not maybe a month or so apart. And if the taxpayer comes in to the Board of Assessors and makes some real good points, even if the Board of Assessors, let's say the Board of Assessors didn't lower the value like they thought they should, but the assessor's sitting over there listening to him, and he goes back and he ponders on a little bit. You know what? That guy has some good points. When I go to the Board of Equalization, I probably need to change our tune a little bit, But he can't present any different documents, even if it helps the taxpayer. The way we got this written, now I'm asking, is that the way it's written? So I'm trying to balance these 2 things. You don't want the taxpayer to be unfairly surprised, but you also want the system to work such that you can bring them. And I thought that's what your question was going to.
To follow up on your point, I thought the law now required like a 10-day period prior to the hearing that no further documents can be presented that were not exchanged within that 10-day period or before that 10-day period. No. Does not.
You've got a valid point that can happen.
You worried about the opposite.
But I think the opposite is probably a lot more prevalent from what and this is from not just the metro area, this is a lot of places I've heard from people on this, that there's nothing perfect here, as you say, but I think it's probably more where the taxpayers getting penalized, not in Cobb County, but in certain places that versus it's to the taxpayer's advantage, or that's not what I hear.
And this is another one of those instances where I could write in there it applies to DeKalb County.
No, I didn't say that.
But here's the other problem, Senator, is that I got a county next door to me. It's got 8,000 people in the whole county. They cannot get people to serve on the Board of Equalization. you have 30 appeals, and these people want to quit because, you know, it just, I mean, you can't get them trained, you can't get them to serve. Right. So sometimes what happens is that the Board of Assessors hearing takes place, and they've got 3 staff. The whole assessing office is 3 staff, the 1 assessor and 2 people helping him. Okay, that's it. Okay, and then so it goes to the Board of Equalization, and then they pick up the phone and they call me, and they ask me as a county attorney to help them. And then I get involved in it, and I figure out they didn't handle it right, in my opinion, the assessors, and they need to make some changes and they need to do something different. But I can't bring at that point to the Board of Equalization anything different than what was given at the Board of Assessors, if I understand this correctly. And I'm trying to figure out the balance to get what you want. Plus,
let's get to a back and forth exchange. I got other people who want to talk about the questions on the bill. Ms. Stevenson.
All right. Someone mentioned DeKalb, so I'm going to say this may be the only time that Mike and Fran and I are probably in agreement, but I have a question. And I'm trying to work through it because Chairman Fleming addressed one of the issues. But when we go to Section 2, I understand the 180 days, but do you really want to say that within 30 days, if the Board of Equalization fails to have the required that the taxpayers, I mean, because good cause, something, well, I'm saying 45.
It's going up to 90.
It's going to 90 days.
But even if it says 90, are we saying there's never going to be a good cause that it can be extended? Snowstorm?
Right.
Is it an amendment?
Well, it's part of the amendment.
Okay.
Yes, sir. Go ahead.
It's part of the amendment, and you have to read this very carefully to kind of figure out how all this lays out timing-wise. But the way it works is that the Board of Tax Assessors has to provide a response to the appeal within 180 days of the appeal being filed. Then, the way we have it in the bill here, 30 days after that, the hearing has to be held. We're going to actually extend that to 90 days, and the 90 days is going to apply to the first noticed hearing. So the hearing could be extended for a providential cause, if in your snowstorm example, or the taxpayer has a unilateral right to extend the hearing one time.
I saw that unilateral
one time again.
Right.
That's why I was wondering if there was some mirror or something there. But you're saying I haven't seen that amendment,
so the 90 days would apply only to the first set hearing. And then this 20 days and 30 days actually fits within the 90 days. It's you know, after you provide the notice, the hearing can't be sooner than 20 days, but later than 30 days after you provide the notice. So
I was responding to the fact that the taxpayer could take a unilateral extension, but maybe it's in the amendment. I have not seen that.
It is. It's handled by the amendment.
Okay. Thank you.
All right. Any further questions among the committee members? And we have before us then Senate Bill 293 is 6035 ERS. Do I have a motion? Motion is due pass. Is there a second to it?
Second.
Have a second. Discussions? No further discussion. We're going to have amendments. I recognize Mr. Jacobs for an amendment.
Why don't I start with amendment number 2, actually. And I'm going to revise this amendment a little bit. To insert on line 24, after Board of Tax Assessors, may orally or using new documents respond to information or documents provided by the taxpayer during any hearing and. So they're not bound to the I mean, I think it's fair that if the taxpayer raises a point, the Board of Assessors has to present their case using what they gave the taxpayer. Then the taxpayer presents their case. And at that point, if there's something that's responsive, they should be able to use new documents. I think that's fair. So the amendment would be may orally or using new documents respond to, strike from the amendment or clarify, respond to information or documents provided by the taxpayer during any hearing and then it would continue and may change or
Is the
alter.
amendment understood? Do we have a? To strike out clarify or clarify.
Correct.
Just as he stated the amendment. Do you have that? I do now. Second to the amendment? Second. We have a second. Any further discussion on the amendment? On the Jacobs Amendment number 2, all signify by saying aye.
Aye.
Opposed, like sign. Actually, your first amendment. Do you have another amendment, Mr. Jacobs?
Yes, the first amendment is AM 400106ER. And it basically replaces lines 45 through 48 in their entirety to make clear that the notice has to be sent for a scheduled hearing, a first scheduled hearing within 90 days of the Board of Tax Assessors' response to the taxpayer. Otherwise, the value that the taxpayer has given will be the value.
Does everyone have the amendment? Jacobs Amendment 401006ER. Do we have a second to the amendment? It's been seconded. Any discussion on the amendment? No discussion. The chair calls the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Amendments added. We have further amendments. Mr. Fleming.
Thank you, Mr. Chairman. I think what Senator Miller was mostly talking about was residential properties and people having trouble with those, and therefore the assessor with us brought up a point that on line 21, could we include such words to say that this is going to go to residential properties but not commercials for the reasons that I think he aptly stated. And, Mr. Chairman, if you want to use your wiser mind to help me with this, but I was thinking maybe we would say at the beginning of that sentence on line 21 that starts with the word after, for residential properties only, comma.
So you begin the sentence.
I'm looking at him and I'm looking at
All
him.
right, let's wait a minute. Let me get his amendment first of all, then we'll get a clarification. Where do you putting in?
Right, before the word after on line 21.
When considering a residential property?
Or I was going to say for residential properties only.
Okay.
That might be even clearer. And if I misunderstood and Mr. Jacobs wants to correct me, I'm happy to hear from him if the chairman will allow him.
I don't know why we need to have to provide to say for residential properties, the documents provided to the taxpayer shall not change. You follow my point there? Let me do something here.
I see what you're saying. Strike after and providing. And
when addressing residential property, comma, the documents provided to the taxpayer, the Board of Assessors cannot change the documents which have been provided to the taxpayer. Let me read the way I think it should be.
Absolutely.
I wish I had Jill here. When addressing residential property, comma, the documents which have been provided to the taxpayer by the Board of Tax Assessors shall not change, alter, or supplement the I'm sorry. Let me say again. When addressing residential property, the documents provided to the taxpayer, comma, that one doesn't read right either.
Well, I thought
that we'll listen to what the tax assessor said, because you do have a difference of commercial property as far as information coming in continuously that may address rental values, perhaps other things that you're using for that purpose.
That's correct, Mr. Chairman. It mainly revolves around commercial properties, malls, offices, where you've got leases and vacancy rates, and all that's the information that you're using to come to the value. You're not getting income-producing properties. You're not getting comparables. That's not the approach to value you're using on those.
And also, Mr. Chairman, I think that didn't cloud at all what Mr. Senator Miller was trying to do. He's really mostly concerned about residential property.
Very flexible.
Did you want to address this, Mr. Welch? Did you have it?
No, sir.
Yeah, Mr. Jacobs.
Well, if that's the intent, I mean, why not? Why not just say this paragraph shall only apply to residential properties at the end of the whole paragraph?
I do the same thing. It'd be fine.
Second. So at the very end on line 25, you want to provide that this paragraph shall only apply to residential property.
It's far too simple, Mr. Chairman. Something got to be wrong with it.
I'm just trying to
So
turn
that's
it
your
on when it
amendment.
gets more than 3 pages.
Hold
That's
on,
all I'm trying to figure out.
Mr. Miller, let's all be quiet. This paragraph shall apply only to residential property. Is that what you want to add? I'm asking you a question.
That I think is the best way to do it. So yes, this paragraph, and I assume one.
As amendment?
I always have Ms. Travis here to correct me on whether the number 1 is a paragraph. That's a paragraph, right?
It is.
Okay. Yeah, this paragraph shall apply only to residential property.
All right, that's at the very end,
Properties.
line 25. We have that as a motion. Jacob's motion 3. Do we have a second?
Second.
Have a second. Any further discussion? No further discussion. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Mr. Welch, you have an amendment?
Yes, sir. Thank you, Mr. Chairman. You have AM 340647 in your folder. The amendment will need to be changed because it's referencing a different LC number than the one we are currently working off of. So let me make that change. On line 1 of the amendment, it should be LC 296035 ERS.
All right.
And then on line
You want to
4.
explain your...
Oh, and then
Okay.
on line 4, we're going to be inserting this between lines 29 and 30 of the current committee substitute.
Okay.
So those will need to be corrections. But the amendment, Mr. Chairman, is essentially allows for what we're seeing from the assessors. We've talked with Cherokee County and Gwinnett County and Henry County and Paulding County, and ACCG I think was here as well. And so this information is coming from various assessors across the metropolitan Atlanta area where we're seeing residential growth in values increasing. The problem, what we've had is we've had a downturn in the market, and as we've had the downturn, assessors have appropriately assessed properties to reflect the market downturn. Now the market is turning upwards, and what we're trying to do is give time for those assessors to catch up in terms of their assessed values and making sure that ratio corresponds to a limited time frame, a period of time to catch up.
All right. Is there anyone wish to speak to this proposed amendment of Mr. Welch? I'll open it up for discussion. You have... Go ahead, Mr. Jacobs.
Representative Welch, I presume, because in looking at your amendment, it also doesn't line up anymore in terms of how it revises the title of the bill. I presume you will give Ms. Travis artistic license to properly fix the title of the bill.
Yes, sir, I will. I appreciate that. It's supposed to be, yes, that will need to be done.
As I read it, I only can say I wish I could understand what it means.
I thought it was just me, Mr. Chairman. Thank you very much.
I'll speak up. No, I'll speak up on that one.
And let me explain. What happens is that you have the standard ratio is in terms of an audit.
No problem.
Okay, never mind. So
You had us at hello. Yeah, exactly.
Thank you.
Thank you.
All I said, I wish I could understand it. Just say it, explain it.
Sorry. I'll leave it alone.
Yeah. We had a motion to amend by Welch. It's been seconded. Any discussion further on the motion? All in favor of the motion to amend the Welch amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do we have any further amendments? There are no further amendments. The chair will call the main question, which is the due pass of Senate Bill 293 as amended and a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. I think that completes our business for today.